A supplemental needs trust is a legislation-created device that allows chronically disabled people to benefit from income and asset-based government assistance programs, even when they might have other sources of revenue. The theory behind this allowance of this device is that if a disabled person's assets were required to pay for his or her health care, there would be nothing left to pay for quality-of-life expenses. In addition, the risk to eligibility for government assistance would otherwise greatly discourage gifts to people with disabilities. A supplemental needs trust can be established as a lifetime or testamentary trust. That is, a supplemental needs trust can be set up either while the grantor is living or by a will, to take effect only upon the death of the client. The latter is a common approach for people who have disabled children. Rather than giving the disabled person an inheritance outright, thereby potentially threatening her eligibility to receive government assistance, the disabled child's share can be held for her benefit in a testamentary supplemental needs trust. The provision establishing that one child's share is held in trust need not even specifically reference the disabled child. It can be worded something to this effect. Upon my death, my assets shall be distributed to my children in equal shares, provided, however, that if any beneficiary under this paragraph suffers from a severe and chronic disability, then his or her share shall not be distributed to the beneficiary outright, but shall instead be held for the benefit of the beneficiary in a supplemental needs trust. Although this type of trust is respected by courts even without statutory recognition, many states have given formal statutory recognition to supplemental needs trusts. In addition, since the passage of the Omnibus Budget Reconciliation Act of 1993, there is also federal statutory recognition of the supplemental needs trust. The exact language by which a supplemental needs trust should be established may vary from state to state. However, a common thread is that the trust should evince a clear intent that the trust assets are intended to supplement and not supplant government assistance to the disabled beneficiary. In addition, the trust may be used only to pay expenses that would not otherwise be paid for by government assistance programs. Assets held by a supplemental needs trust are typically used to pay for things like education, clothing, and luxuries for the beneficiary, such as travel, entertainment, etc. The trustee may be given discretion within this range of possibilities to use the trust funds, as long as the trustee may not pay for expenses that government assistance would otherwise pay for. The trust may give the trustee the authority to invest the trust assets and manage the trust assets in the same manner that trustees are given these authorities in other trusts. Beyond the clear intent that the trustee cannot use the assets in a way that would supplant government benefits, there's little to distinguish supplemental needs trusts from other trusts. A third-party supplemental needs trust is the most straightforward of the supplemental needs trusts. A supplemental needs trust is a third-party trust when assets other than those belonging to the disabled person fund the trust. To keep its status as a third-party trust, no funds belonging to the disabled person, nor funds to which the disabled person is entitled, should be used to fund it. These trusts are usually funded by relatives or friends of the disabled beneficiary. Testamentary trusts, because they're funded by the will of another person, are inherently third-party supplemental needs trusts. A testamentary supplemental needs trust can be quite broad in the discretion it gives to the trustee, while protecting the eligibility of the disabled beneficiary. As long as the disabled beneficiary doesn't have control over distributions from the trust, in other words, that the decision is made by an independent trustee, the assets in the trust shouldn't be considered an available resource to the disabled beneficiary. Third parties, supplemental needs trusts, have little to distinguish them from other trusts, but it's critical that the trust avoid directing the trustee to pay for the health care or similar expenses of the beneficiary. Where the trustee is directed to pay for the health care or general support needs of the disabled beneficiary, or perhaps even when the trustee has the authority to do so, it's possible that a local Department of Social Services will consider the trust assets to be an available resource for the beneficiary. It's important to note, however, that even where the provisions of a third-party trust do not conform to the supplemental needs trust requirements, courts do have the authority to reform a provision, to turn a trust into a qualifying supplemental needs trust. Things become more complex when supplemental needs trusts are established using the assets of the disabled person. Despite the general rule that assets held in any self-settled trusts are vulnerable to the creditors of the grantor, federal law exempts the assets in qualifying supplemental needs trusts from inclusion as available resources to the disabled person who funds it. In other words, if a disabled person has resources that would make him ineligible for government assistance, he can create a supplemental needs trust, use those assets to fund it, and then continue receiving government assistance. Unlike the third-party trust, however, there are strict conditions that must be followed for a self-settled trust to gain the benefits of a supplemental needs trust. First, The trust must be established by the disabled person himself, by the disabled person's parent, grandparent, or legal guardian, or by a court on behalf of the disabled person. Second, the trust must be established for a disabled person under the age of 65. Third, and most significantly, the trust must contain a payback provision. This provision must dictate that upon the death of the disabled beneficiary, any money that's remaining in the trust will be used to reimburse the state that paid healthcare costs for the beneficiary, up to the amount that it paid on behalf of the beneficiary. Any amount left over after this reimbursement can be distributed in accordance with whatever the trust dictates, such as to the beneficiary's heirs. Essentially, the government is saying, we'll let you, the disabled person, keep your money for supplemental needs for yourself, but if there's anything left over when you don't need it anymore because you're dead, we get first crack at whatever's left. The logic behind this is simple. The purpose of the Supplemental Needs Trust was to allow the disabled person quality of life that would be lacking if he used his own resources to pay for his healthcare expenses. The purpose was not to allow the disabled person's family a windfall while the government pays for healthcare of the disabled person. Without this provision, the payback provision, a trust will not qualify as a supplemental needs trust. In that case, the entire trust corpus will be considered an available resource to the disabled beneficiary, likely disqualifying him from receiving types of government assistance. If there are self-settled and supplemental needs trusts for the benefit of the same disabled beneficiary, the family of the beneficiary should be advised that if any member wants to give substantial assets to the disabled person, she should do so by giving those assets to the third-party trust. This applies both to lifetime gifts and testamentary gifts. This is because the third-party trust does not require a payback provision. Placing a gift in a self-settled trust likely means at some point that the money is going to wind up going to the government. The next question is whether a supplemental needs trust may benefit additional parties in addition to the disabled person. A standard trust, whether a qualifying supplemental needs trust or not, can benefit a disabled person as well as other third parties. As long as the trustee is not required to pay expenses for the disabled beneficiary that would be covered by government assistance, the trust should not adversely impact the disabled person's eligibility. The same applies to supplemental needs trusts. Although supplemental needs trusts typically benefit only the disabled person, there's probably no problem with having other people potentially benefit from a third-party supplemental needs trust. In addition, third parties may and should be named as remainder beneficiaries, in case the trust assets remain after the death of the disabled beneficiary. A self-settled supplemental needs trust, on the other hand, is another matter. Since the state must, by definition, have a remainder interest in the trust assets, it naturally has an interest in preserving those trust assets. As such, in a self-settled supplemental needs trust, no person other than the disabled beneficiary may be a beneficiary of the trust, whether during the lifetime of the disabled beneficiary or after his death, until the payback has been satisfied. Once the government gets its money, then any remaining money in the trust can go to the other heirs of the disabled beneficiary. The Miller Trust, also referred to as a qualified income trust, serves as a vehicle to hold income of a disabled person that exceeds the state limit for Medicaid eligibility. This excess income, from pensions or Social Security for example, can be placed into a Miller Trust rather than being held by the beneficiary, and thus allow such person to become eligible for Medicaid. Named after a 1990 case of the same name, the Miller Trust was codified as part of the 1993 Act that also established the rules for self-settled supplemental needs trusts that we discussed earlier. Unlike a self-settled supplemental needs trust, this device can be used for people over the age of 65. As with a self-settled supplemental needs trust, the trust may be used for the benefit of the disabled person, but only in a manner that will supplement and not replace payments that would otherwise be made by government assistance. Also, as in the case of a self-settled supplemental needs trust, Miller trusts require payback provisions. So, any trust assets that are unused at the time of the beneficiary's death must be used to reimburse the state for expenses paid on behalf of the disabled person. Any assets remaining after this reimbursement to the state may be paid to the disabled person's heirs, in accordance with the wishes of the disabled person. An alternative to the Miller Trust, also codified by the 1993 Act, is the pooled trust that is held by a nonprofit organization. The nonprofit organization establishes a trust where many disabled people pool their resources to be managed and invested by the organization. Separate accounts must be held for each disabled beneficiary, and the separate accounts must be set up by the disabled beneficiary or by the parent, grandparent, or legal guardian of the beneficiary, or by a court. The disabled person can fund his or her own account in the pooled trust with assets to lower asset holdings below the Medicaid thresholds, and may consistently fund the pooled trust with income that exceeds the Medicaid income threshold. The trust may use the disabled beneficiary's account to pay for the beneficiary's supplemental needs. Unlike the self-settled trust and the Miller Trust, at the death of the disabled beneficiary, there's some flexibility in the pooled trust. The trust has two choices. The first choice is to have the beneficiary's account simply remain with the nonprofit organization and be part of its general nonprofit purpose. In that case, the state need not be reimbursed for the care provided to the beneficiaries. Alternatively, the trust may pay back the state for the care it provided to the beneficiary, and the remainder can then be distributed to the heirs of the beneficiary. In most states, there is no age restriction on who can fund a pooled trust. This is an important advantage over the self-settled supplemental needs trust. Of course, the downside of the pooled trust strategy is that the organization maintains control over the trust assets and must approve expenditures on behalf of the beneficiary. With a supplemental needs trust, it will be recalled, a family member or friend can be the trustee and thus control distributions to the disabled beneficiary. In addition to the important benefits of preserving or maintaining a disabled beneficiary's eligibility for government assistance programs, supplemental needs trusts provide another important statutory advantage. Recall gift transfers typically cause a 5-year period of ineligibility to receive Medicaid assistance. A transfer to a qualified supplemental needs trust, on the other hand, does not result in a period of ineligibility for the donor. If the disabled beneficiary of the trust is a spouse or child of the grantor, then the disabled beneficiary may be of any age. If the disabled beneficiary is someone else, the beneficiary must be younger than age 65. In addition to the other statutory requirements of a supplemental needs trust, to be eligible for this transfer exemption, the trust must be for the sole benefit of the disabled beneficiary. This is true even if the transfer is made to a third-party supplemental needs trust. Since a supplemental needs trust to which the transfer is made is generally a third-party trust, a payback provision is not required. However, the gift to the supplemental needs trust must be such, based on actuarial data, that it's reasonable to expect that the amount transferred will be spent over the course of the life of the disabled beneficiary. The reason for this is simple. If the gift is large enough that it will likely not be spent during the lifetime of the beneficiary, then the entire gift cannot reasonably be considered for the benefit of the disabled beneficiary. Unfortunately, this only works to avoid the transfer ineligibility period. If a person has consistent income exceeding the Medicaid income limitations, transferring the excess income to a supplemental needs trust for the benefit of a disabled child will not prevent it from being considered available to the recipient of the income. One last possible benefit of transferring assets to a supplemental needs trust is that some states will not recover assets paid by Medicaid after the recipient's death, if the assets are left to a supplemental needs trust for the benefit of a disabled beneficiary. Typically, if Medicaid pays for the care of a person who dies with assets, the state is required by law to seek recovery of the expenses that were laid out. However, at least one state, California, expressly states that it will not seek to recover such assets if they are left to a supplemental needs trust.